A huge win today in the state of New York. Federal District Court Judge John Sinatra has found that New York's so-called vampire rule, or the default and you cannot carry a gun in public rule without the permission of the stores into which you go rule, Judge John Sinatra has found this to be unconstitutional under the Second Amendment and may not be enforced. We're going to break down this decision in Christian versus James when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. All right, folks, major decision here. Congratulations to the Firearms Policy Coalition and to the Second Amendment Foundation for their big win today in the United States District Court for the Western District of New York. That's the Niagara Falls, Buffalo, New York area, that found that New York State's so-called vampire rule that says that you're not allowed to go into a public place of business, a convenience store, a grocery store, a supermarket, a gas station, public restroom, any of these things, without first and foremost getting express consent to carry your gun into those otherwise open to the public venues. Judge John Sinatra concluded that there was unconstitutional under the Second Amendment, and that the text of the Second Amendment, the right of the people to keep and bear arms, was implicated by virtue of this New York state law that said you cannot carry guns into these places without first getting express permission from the owner to do so. And because the text was implicated, Judge John Sinatra shifted the burden in the Christian case to the government to come forth to show, if they could, there's a long-standing historical tradition of restrictions that would allow New York State to enact this kind of law. After assessing a whole host of laws proffered by the state of New York, Judge Sinatra said none of these came close to justifying a long-standing tradition going back to the founding of basically government laws forbidding the carrying of guns, even if you have a concealed carry permit, into places without first and foremost getting permission from the owners. Judge Sinatra distinguished all of the laws that the government had proffered, saying that none of them were persuasive and none of them demonstrated any kind of a tradition, and certainly not a historical tradition of firearms regulation that said the government can say you can't bring guns onto property, even the concealed carry permit, without getting permission from the owners first. I should also note that the government tried desperately, as I predicted many years ago, at this point, multiple years ago, that they would try to rely heavily on late 19th century laws after the Civil War to try to justify their gun control laws, because there was a whole host of laws enacted after the Civil War to try to disarm the freed African-American former slaves. And New York went down this path as predicted and tried to justify these laws with 19th century gun control laws after the Civil War. But I'm happy to report that Judge Sinatra was having none of it. This is what Judge Sinatra said about New York State's attempt to use these late 19th century laws. The Reconstruction enactments, when considered with the founding era enactments, do not demonstrate any tradition at all. Here, the cited enactments are also unknown and of a limited duration, and the state has not demonstrated endurance over time. To the extent any tradition at all can be discerned from this amalgam of enactments, it would relate to regulation of hunting and trespassing with guns on enclosed or improved lands of others. Powerful language there by Judge John Sinatra about the uselessness of late 19th century laws, but then he goes on and makes another point, specifically pointing out that, as the Supreme Court has said, that the only way that 19th century gun control laws can be relevant is as a confirmatory analytic. As a confirmatory analytic, powerful language by Judge Sinatra, consistent with what I've written about in the past. I think this will sound very familiar to you who follow the Four Boxes Diner. So let's see what Judge John Sinatra had to say about further reasons why this late 19th century precedent was no good for the state of New York. Here's what he says. Finally, even if the state's collection of Reconstruction era enactments could, separately from the founding era enactments, be read as creating some sort of emergent tradition, that could not alter the outcome here. Bruin made it clear that to the extent later history contradicts what the text says, the text controls. Thus, post-ratification adoption or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text. As discussed, the Second and 14th Amendments protects an individual's right to carry a handgun for self-defense outside the home. And on this historical record, that right is equally recognized on private property open to the public. The cited Reconstruction era enactments, therefore, can serve only as a mere confirmation, hear what I just said, as a mere confirmation of what the court thought had already been established. So great language there. So bottom line is the state of New York has lost big time in front of the federal district court judge John Sinatra in the Western District of New York. Basically, the judge went on to say that despite the fact that the state has requested the stay of his order, he is not going to do so, pointing out that this law has essentially been rejected by almost 2 years now by other courts. And he went on to say that there are some other pending issues in front of him, but such as whether or not public parks, you can ban guns in public parks. But he notes that these are issues that the United States Court of Appeals for the Second Circuit are addressing right now in the Antonyuk case. So he's not going to get involved with deciding those because the Superior Court, the Second Circuit Court of Appeals, is going to be dealing with those first. So he dealt with the one issue that's squarely in front of him, which is the so-called default no carry provision, or the vampire rule, whatever you want to call it. And he has resolved that in favor of the Second Amendment and against government. Powerful decision. Congratulations again that the Second Amendment Foundation and to the Firearms Policy Coalition for their win today in Christian versus James. And we will keep you abreast as things develop in this case. Make sure you follow me on X, of course. Don't forget to like this video and subscribe. We're trying to grow our numbers. And we will see you again very soon here at the Four Boxes Diner.
Orders up. Table 2A.